Well, good morning, good afternoon, good evening, whichever it is for you. Welcome to the core, really, of our criminal justice, criminal law class here at Wake Tech. We're going to actually be starting to go through the specific statutes and crimes. We've laid a lot of the groundwork here so we can understand this, the background, and now we've got the practical application. So one of the things that's going to be a little bit different than the text you're using is the text is very generic. It's really been created so it can be used in multiple states and multiple colleges. This is going to have a little bit more of a focus on North Carolina material. So we'll talk about, the six major homicide statutes in North Carolina. I know there's more than six, but the big six would be, first-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter, felony death by motor vehicle, and misdemeanor death by motor vehicle. Though there are a few others, like I said, but those would be the core, and we'll give you reference to them and help you understand them. So I think this is where the course gets particularly interesting for most students. Some of them get a little bored with laying the foundation that you really need to understand these, because you've got to clear away a lot of the misconceptions you have coming into this, which are really gathered from popular culture and some misunderstandings. So having said that, let's go ahead and let's take a look at homicide. So what is homicide? Well, homicide is the death of any person caused by another person. Now, some homicides or some killings, if you prefer, are justifiable. If someone is coming at you with an axe and says they're going to kill you, and they are the aggressor and you didn't do anything to deserve that, that is a justifiable homicide. There can be excusable homicides, but the ones that we're focusing on are the homicides that are crimes. And once we decide that this taking of a human life is improper, is wrong, we've got to then we've got to then classify or subcategorize what it is. Is it a murder, a first-degree murder, a second-degree murder? Is it a manslaughter? Is it some sort of negligent homicide? Is it something that doesn't rise to that level? So most jurisdictions will use the terms murder, manslaughter, and then negligent, and we're talking about criminal negligent homicide. And of course, penalties are one of the things that really distinguishes these, as well as intent. So North Carolina, we've got two critical statutes that you should look at if you're studying homicide in North Carolina. The first is North Carolina General Statute 14-17, and that's going to cover first-degree murder and second-degree murder. Now, first-degree murder is going to include felony murders, and I'm going to explain more about that in a second. And then we have the manslaughter statutes, and that should be, I believe, 14-18, not 12-18, like it says on your slide there, and I'll go back and correct that. So we're looking at voluntary manslaughter, involuntary manslaughter, and then you're looking at the vehicular homicides, vehicular manslaughters. Because, one of the things is, yes, there are these first-degree murders, these felony murder rules that can get triggered, but a majority of deaths probably are caused in some way or another by automobiles. So very important. All right, the corpus delicti requirement. Now, corpus delicti is sometimes confused when people think, well, that means the body of the victim. And that's not actually what it means. What it means is the body or the substance of the crime. So proving the corpus delicti means you're proving, you could say it this way, each and every element of the crime. So one of the things you have to prove at a minimum, whether we're talking about the first-degree murder or whether we're talking about a negligent homicide, is that someone is dead. That's why sometimes there's confusion here about the corpus delicti being the body. Can you produce the body of the deceased? Because that's going to confirm they're dead. Now, sometimes you can't, but that's okay. If I put a bomb aboard an airplane and you could prove I did this and the airplane flew over the ocean and blew up and there were people on board, you might not be able to recover the bodies. But they're all dead. So you could still prove the taking of a life. But 99 times out of 100, what we're talking about here is we've got a body, we've got evidence that there was violence done to the body, that the person was killed, that the person charged with it, the defendant, is the one who caused the death, and that this death was unlawful. And the scope, the magnitude of the crime, the seriousness of the crime is really going to be how they caused that. Did they do it knowingly, premeditatively? Did they do it purposely? Was it just reckless? Was it just negligent, which is the least? Now, it can be very hard to prosecute if you don't produce a body, or if you can't produce a body and a cause of death. So there's a ongoing case right now, and it's 2024 here in North Carolina as I record this, where an individual has been charged with a homicide. They did an autopsy on a body that was found in the woods, and he has been unable, or they have been unable to determine cause of death. So his argument is not that you don't have the body, but that you can't prove the death. Why did that person in the woods die? Did they go and die in exposure? Did they have a heart attack? What was the death? So when we talk about body, sometimes you've actually got the physical body, and sometimes it's hard to prove why someone died. So very often, what are we looking for here? Confessions. Confessions are very key to homicides, because often they're going to be the only glimpse we have into motivation. Why did the person do this? And you can see that why could be important if we're looking at, well, did the person do it knowingly? Right? Then the why they did it was they chose to do it. Or at the lower end of the spectrum, did they do it negligently? Well, I just wasn't paying attention. So confessions are very important. But in some circumstances, of course, they can be dismissed in court. We can say the confession was given without a Miranda, or the confession was given under coercion. All right, well, we do need proof that the victim was alive. Homicide requires that we have a dead person. Now, we're starting to get into almost metaphysical questions when we talk about what is life. In most jurisdictions, we go back to the heartbeat. And this is something, of course, that is bedeviling or causing controversy in the abortion debate. Is a fetus a human being once its heart starts beating? And, the problem here is the heart historically was seen as really the seat of the soul or the human being in many ways. But as our science got more advanced, I would say, we began to understand that the brain is far more important. After all, people can have artificial hearts, right? You can do heart transplants. Famously, Dick Cheney, the former vice president of the United States, his heart didn't work very well, and he had an artificial heart or assistant, so he didn't have much of a pulse. But you wouldn't say that Dick Cheney is not alive. And if we think about the end of life, and this is where we start to apply our science a little bit more to the old law, we look at brain death. Does the person have any brain activity? Now, obviously, you can't kill someone who is already dead. So if I take a gun and I walk into a funeral parlor and there is a body in a casket, and I take a gun out and I shoot that body, that's not going to be a homicide. It can be a crime. It can be violence to a corpse, or it can be desecration, but it's not the crime of homicide. One of the things, and this is a kind of a classic law school exam question they give you, someone has just jumped off a building, they're falling to their death, they're falling, say, from 100 stories, it doesn't really matter, and someone shoots a gun out the window and it hits the person and kills them instantly before they hit the ground. Was there a homicide? And the answer there is yes, there was. It doesn't matter if you're about to die in a minute or an hour or a day or a year. We ask, what is the immediate cause of the death? Now, as I said, some states, I think, applying science a little bit more, and the realization, particularly, I would say, at the end of life as opposed to the beginning, is they go to brain death. And this kind of came up once we had the technology to keep people alive who otherwise would have died, but their brains were okay. And by that I mean you put someone on a heart-lung bypass machine, neither their hearts nor their lungs are working, but they're alive. Or you have, at the other end of the extreme, you have someone whose hearts and lungs are beating, but they're brain dead. In that case, if let's suppose there's an industrial accident, someone is very badly injured, they're brain dead, they're in the hospital, the accident was that person's fault, so there's nobody that we can say killed them. Then if we turn off the machine that's assisting them, keeping them breathing, keeping their heart beating, it's not deemed to be a homicide. In a majority of homicide cases, you've got to come up with the cause of death. So going back to this one in North Carolina I'm talking about now, you're going to have to offer some proof in a court of law that if John killed Jane, that John was the cause of death of Jane, that his actions, that he shot her, that he stabbed her, that he strangled her. If you can't prove that, then it's very, very difficult to prove a homicide case. All right, well, that's kind of the end of it. Let's go back to the beginning. The common law requirement of being born alive. Now, obviously, we have 50 states, 46 states and 4 commonwealths if you prefer. We have 50 states plus the federal government. And each state is its own sovereign government, and it can determine what the criminal law is. And so, this means that different states are going to have and focus on different things, particularly when we look at issues like abortion, which I just mentioned. We have a debate in the United States right now when life begins. Assisted suicide, when is it proper to help someone end their life? We have some states where we have assisted suicide laws, and other states where it's first-degree murder charge. And, of course, termination of life support. When can you turn it off? Okay, so to be able to charge a homicide, you have to prove that, if we're looking at a child or anybody, that the baby was born alive, that the person has alive. Now, a lot of states have pulled back from this, and they have said, well, we don't really require that birth. Some states have adopted fetal heartbeat. They'll say you're alive if you show a heartbeat. Now, some say, well, no, it's got to be brain activity. And other states say, well, this is very, very hard to determine, so we're going to set it at 6 weeks, 8 weeks, 12 weeks, whatever, a number of weeks. Now, sometimes you'll hear this term feticide, which is the murder of an unborn child. And it's kind of the creation, maybe you could be argued the revival of the idea that an abortion is a murder, an abortion below a certain time. End-of-life decisions, on the other hand, or termination of life supports are handled much more informally. The general legislature in North Carolina is not as concerned with what we do with someone who is on life support and shows no brain activity, but still has a heartbeat, than they are with a very young fetus or child that has a heartbeat and no measurable brain activity yet. So end of life we treat a little bit differently than beginning of life. And that's just one of the complexities that we're dealing with in the criminal law. Okay, causation. What you have to do is you have to show that the person charged with the murder is the person who caused the death. They have to show that something they did, or rarely, but it can happen, failed to do, was the proximate cause of harm. Now, obviously, people can have underlying conditions. So if I'm chasing you around the house with an axe and I'm perfectly willing to kill you, and all of a sudden you grab your chest and you have a heart attack because you have a weak heart and you die of the heart attack, you might try to make the argument, well, I didn't kill you, pre-existing condition killed you. But the law would say that the cause and fact, okay, is essentially this. That person wouldn't be dead if you weren't chasing him. So the example that's given here is A shoots B, wounding him. To escape, B jumps in the river and drowns. A's actions are the cause and fact of death. So even though he doesn't shoot him, A is still guilty of the murder if B was trying to escape him. Now, there can be an issue, and this kind of goes to the common law again, of how much time is permissible between the injury and the death. And I was reading a case in North Carolina not too long ago where someone had committed substantial child abuse more than, I think it was 20 years on a child, and then the child growing to adulthood, but with developmental problems and physical problems because of child abuse, finally dies related to the abuse that occurred 20 years ago. At that point, they could charge the abusive adult, even though it was 20 years later. Now, some states will adopt things like a year and a day rule that says if whatever action we're talking about occurred more than a year and a day before, it's not deemed to be proximate cause. So it's pretty much, again, up to any of these 50 jurisdictions and the federal government to make that decision. So what does this all mean when we talk about proximate cause? The proximate or legal cause means that we can go into a courtroom and the person who did it, the defendant, can be held responsible even if the death occurred in a manner that wasn't what that individual was trying to do. And the example here is the offender breaks into a house with an axe, chasing him, and the homeowner dies of a heart attack, not the axe. We can still charge the offender. He can still be the defendant. Now, obviously, sometimes there are external factors that impact when someone dies, and these are usually called intervening causes. Sometimes there can be something that happens that breaks the chain of causation. So here's the example. A stabs B, causing an injury that will be fatal. C comes across B, who robs him and shoots him in the head, causing instant deaths. So who is chargeable with the homicide? Well, because C came in and was the one who actually killed, C is chargeable with the homicide. Now, interestingly enough, don't forget, A can still be charged with the crime. He doesn't walk away here. If he did it trying to kill him, he could be charged with attempted murder. Right? The fact that the person didn't die of the wound doesn't change it. Just because a thief isn't successful in stealing money, just because a murderer isn't successful in killing, doesn't mean there isn't a crime. I'm following the appeal of ex-President Trump from his conviction for a fraud where he filed fraudulent documents in order to get a loan. And his lawyer's argument is, well, it isn't a crime because no one was hurt. And that misses the point. The crime is the filing of the fraudulent documents. Yeah, it would have been worse if he had borrowed that money and the business failed, and when the banks went to collect, the money wasn't there to collect. Yeah, that would have been worse. But the crime was the attempt, okay, to lie but to obtain the loan. Now, subsequent causes that are foreseeable in response to a criminal act are not intervening causes. So let's go back to our first one. A stabs B, and it's a very serious wound. C, a doctor, gives B too much anesthetic, and B dies. So that negligence is foreseeable. A is still chargeable with the homicide. So it seems like when you say, well, no, C's action is there. Well, no, because you were placed in a situation where this happened. So let me give you one that may be a little bit better than this from your book. A stabs B, inflicting a serious wound. B is put in an ambulance. The ambulance is driving the hospital and gets and runs off the road, flips over, and in the resulting accident, B dies. Well, the only reason B is in that ambulance is because A shot him or stabbed him. Therefore, A can still be charged with a homicide. So just because there's something that is another cause of death, I would say, doesn't mean it breaks the chain. Still, even though your book spent some time in this and we just spent some time in this, it's not as critical because in most cases there are no intervening causes or issues like this. All right, so let's talk about murder. Probably right now we're in the midst in America of an explosion in interest in homicides and crime. You've got all these podcasts and TV shows. So murder is something we focus on a lot. Both in the common law, which is this oral law that develops all the way back in medieval England, and statutory law that has been enacted by the 50-odd different state legislatures and the Congress of the United States, has defined murder to include the combination of the physical act and the guilty mind. Now, mental states can vary. So if you think about if I walk into the house to kill my wife and I decided I'm at a bar and I'm drinking, no, let's not even that. In cold blood, I decide I'm going to kill her because, I want to inherit her money. So I go to the house and I take a gun and I shoot my wife. That's premeditated. So if we look at your mind, the mens rea, that's really bad. Okay, and we would say, okay, we're going to charge you with first-degree murder. Second-degree murder, you are going to cause death, but you don't plan it. So I didn't premeditate the crime, but I intended to cause death. Or serious bodily injury. There's no plan. There's no premeditation. That's going to kick you very often to second-degree murder. In most states, unplanned and unintended deaths that occur during the commission of a felony are charged as a first-degree crime. So this is what's called the murder-felony rule. If you kill someone during the commission of a bank robbery, or if you kill someone while you're raping them, or if you kill someone while you're beating them intentionally, okay? Even though you don't have the intent to kill while you were doing these things, the murder felony rule is triggered and you can be charged with a homicide. Okay, so first-degree murder typically includes malice aforethought. Now, malice has been introduced here. This is, in North Carolina, malice is ill will or hatred. So you have, typically in first-degree murder, you have ill will or hatred before, and you have premeditated or deliberated. Now, again, popular culture here tends to elaborate this too much. You have these you have famous murder cases in, fiction, Sherlock Holmes, or, modern ones, kind of hokey ones like Monk on TV, where people premeditate these things. They think them out and they create elaborate plans to kill people. And sure, that's premeditation, but that's pretty rare. When we're talking about premeditation, it's the briefest moment of reflection. Did you have a second or two to draw back and say, yeah, I'm going to do this? That's sufficient for premeditation. Malice aforethought signifies the mental state of a person who voluntarily, without legal excuse or justification, so it's not imperfect self-defense, it's not anger, it's not the discoverance of infidelity, does an act that would ordinarily cause death or serious injury. Premeditation is the actual planning. Premeditation doesn't require, as I said, a long time. But there has to be at least some moment of reflection. So let's look at, I think this is a little bit clearer if you look at specific state statutes. Let's look at North Carolina's first-degree murder statute. Okay, so North Carolina says for first-degree murder, premeditation, willful or deliberate. And then we actually list a number of methods that if you do it, will trigger first-degree murder. So we say, did you poison someone and kill them? Did you torture someone and kill them? Were you lying in wait or ambushing them and kill them? Now, if you think about all of those, poison, torture, ambush, those all are really premeditation. So even though they're separated out, um, they in fact relate back to the idea that you premeditated this. The legislature also recently, in the last few years, has added, did you use a weapon of mass destruction, a chemical, biological, or nuclear weapon, which again would go back to premeditation. But the big one, the absolute big one, and the one that really calls for most of this is the murder felony rule. And we've got a slide coming up on that. But an attempt or a completed arson, an attempt or completed rape, felony sex offense, a robbery, a kidnapping, a burglary, or using a deadly weapon triggers the murder felony rule. We don't need premeditation. We just need to show that you have the intent to commit the underlying felony. Did you intend to rape? Did you intend to burn down the building? Did you intend to rob? That's your premeditation. So even though the murder felony rule is sometimes seen as an addition, in fact, if you think about it, it kind of relates back to that premeditation. All right. Previous conviction for domestic violence. If a spouse, former spouse, or romantic partner is killed, and it was done with violence and malice, malice is ill will and hatred, then a rebuttable presumption arises that it's willful or deliberate. One of the things I tell my students constantly is if you're going to be killed, the odds are you're going to know the person that killed you. And in that smaller category, did you know the person who killed you? The largest group of people are going to be people that you have a close relationship with, a domestic relationship, spouses, boyfriends, girlfriends, parents, children. You charge first-degree murder if you're convicted of domestic violence or violation of a domestic order or stalking or threatening the victim. So let's suppose there's a domestic order against me in North Carolina, a 50B, which says I can't come within 200 yards of you. And I'm obsessed with you, and I am following you in my car home from your place of business or your work or your another house, it doesn't really matter. And you're so terrified of me, you run off the road and you die. You lose control of your car because I'm chasing you in a car in violation of a domestic order, which says you can't do that. Then I would be chargeable with first-degree murder. Now, another thing that can come up is deadly weapon. So, committing a crime by use of a deadly weapon, such as assault with a deadly weapon, is commonly a separate and more serious case. Now, North Carolina has lots of these. We have assault with a deadly weapon. We have assault with a deadly weapon with the intent to inflict serious injury. So in murder cases, the use of a deadly weapon will typically create the inference that you intended and that you had malice. I would say particularly certain kinds of deadly weapons. If you stab somebody, stabbing is a whole nother level of malice, ill will, hatred. The presumption, of course, can be rebutted by showing that you used a deadly weapon in a way that you didn't intend to result in death. So let's suppose you're in a situation and you decide, because you've seen too many movies, you're going to shoot up into the air. And the bullet comes down and strikes someone and kills them. Well, yeah, you did use a deadly weapon, which tend to, under the deadly weapon doctrine, might trigger this murder felony. But okay, you didn't do it with the intent to harm, you just did it with the intent to frighten. So it might be a manslaughter charge. Now, many objects can be deadly weapons besides the obvious ones. I mean, the obvious ones are guns, knives. But even as something as simple as a 2x4, a 2x4 might be something that holds up a wall, or it might be something I swing at you in anger. So what about North Carolina? Well, we have a number of deadly weapon offenses that can trigger this. Discharging a firearm into an occupied vehicle or structure. Felony larceny. Felony child abuse. You might say, felony child abuse, where's the weapon there? Well, the different size is the weapon there. If you're a 35-year-old adult and you're beating a 10-year-old child, your fists are a deadly weapon. Also, things like, and not just limited to cocaine, but I noticed it, sale of cocaine or general drug trafficking can be deemed to be a deadly weapon in some cases. All right, now let's go to something which sometimes confuses students. What happens if you're in a situation where you're going to shoot somebody? So let's suppose Fred is going to shoot Barney, and he shoots at Barney and misses Barney and hits Betty. We're in a Flintstone cartoon here, apparently. This is called transferred intent. If acts are taken with the intent to kill one person, but another person dies, okay, you might say, well, Fred was shooting Barney but killed Betty by accident, therefore it's not an intentional homicide. It's not a first-degree murder. And the law would say no. In most jurisdictions, it doesn't matter if it was an intended victim or an accidental victim if you were trying to kill somebody. And this is transferred intent. And this can be if you kill someone by accident, thinking there's someone else. In other words, I'm going to go kill my wife. I go into my house. I see someone sleeping in my bed. It's not my wife. It's, my daughter. It's my mother-in-law. It doesn't matter. There's someone sleeping in the bed that I think's my wife, and I shoot and kill them. Well, I killed them by accident, but I intended to kill my wife. So we would say under transfer intent doctrine, it's going to be a first-degree murder. So North Carolina adopts this. The actual victim does not matter. Just did you intend to harm someone? And the common phrase that we use here, and it's kind of a nice phrase, is intent follows the bullet. So this very often happens when people start shooting guns and innocent civilians get hit. So if I'm shooting at a police officer and I hit a civilian, okay, then it's a first-degree murder charge. You might say, well, I didn't intend to shoot the pedestrian walking behind the cop. I was shooting at the cop. Yeah, well, you didn't have a right to shoot at the cop. It's a first-degree murder charge if you hit him. And you hit the civilian walking behind, so it's first-degree murder. All right, well, that's a lot of the first degree. Let's go to the second crime in many jurisdictions and in North Carolina, second-degree murder. And then we'll go to specific North Carolinas in a minute. It can get called different things in different states. So sometimes you'll hear it called, and this language can be very flowery, very elaborate, depraved heart murder, serious bodily harm. But basically, you kill someone without the intent to cause death, but you may have intended to cause serious bodily harm, or you were so reckless that it demonstrated, and we don't use in North Carolina depraved heart much. We tend to use deliberate indifference. Depraved heart murders typically involve acting with extreme indifference to the value of human life. Second-degree murder does not have a premeditation. It doesn't focus as much on the deliberation or the thinking about it. So let's go to North Carolina's second-degree murder statute. It's an intentional killing, okay, with malice. So you're demonstrating ill will or hatred, but you don't premeditate, and the murder felony rule is not there. So common examples in North Carolina: murder committed rashly or by impulse without thought. You get up in the middle of the night, you go into your daughter's room, and the daughter's boyfriend has snuck into the house, and you kill him. You didn't intend to kill the boyfriend, but you have this jealousy or rage and you kill. That would be a second-degree murder charge typically. Although, if you went back to your room and got a gun and loaded it and went back in and shot him, it's a first degree because that's premeditation. But if you hear a noise in the house, you grab your gun, you walk into your daughter's bedroom, there is the boyfriend in bed with your daughter, and it enrages you so, and without thinking about it, you shoot him, that could be a second-degree murder. It can be murder that results from the intent to cause great harm, but not death. Essentially, you get carried away beating someone. Or murder that shows a disregard for human life. Now, one of the ones that sadly is common in North Carolina is North Carolina death by distribution. This is North Carolina General Statute 14.4. If you distribute or sell a controlled substance and death results. And we're going to talk about the most common ones: opiates, coke, and we don't mean Coca-Cola there, obviously, meth, barbiturates, all of those. If you can show malice, if I sell you drugs and I did it with ill will or hatred, we can bump this up to a second-degree murder charge. So we have death by distribution in North Carolina. Now, I promised you we'd talk about the murder felony rule and then the specific ones. As I said, most states and the federal government, and this is probably, if we look at all the first-degree murder charges, where most of them come from. I don't have specific numbers on that, but I would say that's a probable event. Most states and the federal government have murder felony statutes, and we'll look at North Carolina's in just a second. If a person dies during the course of a different but related felony, the person who commits it, can be charged with murder. A felony murder conviction does not require that you show malice or deliberation. The felony act itself is your intent. So let's look at the North Carolina rule. North Carolina murder felony rule makes it a first-degree murder charge. And usually in North Carolina, you are committing some serious crime, like bank robbery, and someone dies. And, the defense might be, well, I didn't intend for them to die, and the law would say, we don't care. Now, the scary thing about this, for people that are involved in crime, is you don't have to have any knowledge that this will occur. So, quick example here. You drive your friend to a liquor store, and he goes in and says, I'm going to get us that liquor one way or another. And you say, geez, sounds like he's going to steal it. So he goes in, and he pulls a gun out, and he steals a bottle of liquor, and the clerk tries to stop him, and he shoots and kills the clerk. Now, he comes out of the car, he's got a bottle of liquor in one hand, a smoking gun in another. You just saw him shoot the clerk. If you drive away with him, you have aided and abetted him after the fact, you are part of the murder felony rule. You can be convicted of first-degree murder and executed. So you got to be real careful once you're involved with other criminals. All right, let's go to this second level of murders. We have kind of the first level, which are your first and second degree murder. And now we get to the manslaughter. So manslaughter, like first degree and second degree murder is divided into two, manslaughter is divided into two, the voluntary and the involuntary. So now some states only have one, other states have three. They have voluntary, involuntary, and vehicular. Typically, involuntary manslaughter, which is the second level, there's no intent to kill, but you're doing something really bad. Not bad enough to trigger the murder felony rule, but bad. Voluntary manslaughter, you don't have this premeditation, you don't have the malice, the ill will or hatred, but you can have heat of the moment. So let's go back. I gave the example of catching your daughter's boyfriend in bed with her. Like I said, if you walk in and in the heat of the moment, if you've got a gun with you, that might be a voluntary manslaughter. But if you have to go back to the bedroom and load a gun and come back and shoot the boyfriend, that's first-degree murder. Why? Because you didn't have the premeditation and your intent, right, to kill. Until you walked into that room, you weren't going to kill. Probably the one that has caused the most debate in society is not heat of the moment homicides, although they're important, but really the imperfect self-defense. And we'll look at those in a second. But let's go back to the first category of manslaughter, kind of almost the triggers of manslaughter. That's the heat of passion argument. All states provide a lesser charge of murder to voluntary manslaughter where it happens in the heat of passion. We are emotional creatures. There can be something that can trigger a reaction. Now, sometimes that triggered emotional reaction is sufficient to excuse the entire crime, particularly if the other party is doing something really wrong. It's bad, arguably, that someone is sleeping with your underage daughter. It's a terrible thing. If you have a 17-year-old boyfriend who's sleeping with your 12-year-old daughter, that's a terrible thing, right? You still might be charged with a manslaughter if you kill him. But if you came into the bedroom and a burglar had broken into the house and was committing a rape, then and you snap and you kill him, okay, that's perfectly excusable. Okay, what we're looking at is in manslaughter situations where you probably shouldn't do it, you probably shouldn't take the fatal action, but you're provoked. And a reasonable person would lose self-control. But if there's any time to cool off, if it's back to the other bedroom to get the gun, if there's any time to, take a breath and say, not do it, you're going to have a problem. So one of the more common ones we see is improper self-defense. Now, this has changed. This has changed a lot since I've been a lawyer, and I've been a lawyer since the 80s. Back in the 80s, in North Carolina, if we use our example, you had what was called a duty to retreat. So perfect self-defense was you're faced with a threat. The only way you can escape the threat is to use deadly force. Now, it used to be in the past, you used deadly force or if you could safely retreat. Quick example to make it simple. Someone's coming at you with an axe. You could step behind a door, lock it, and they couldn't get in your house. Or you're standing on your front porch, you have a pistol, they're coming at you with an axe. Now, you could retreat or you could shoot them. You've got two options. Under the old law, the duty to retreat, you had to retreat. Under the new law in North Carolina, the stand your own ground law, and this comes out of Florida. Florida man raises its head again. Under the new law, you don't have to retreat. So perfect self-defense has become a little bit easier. If the homicide is justifiable or excusable, there's no crime. Are you faced with an immediate physical threat to your life or safety? Is someone saying they're going to kill you? Is someone saying they're going to rape you? Is someone saying they're going to beat you to a pulp? Then you got perfect self-defense. But sometimes you don't have enough. We have imperfect self-defense. You don't yourself believe, or it's unreasonable to believe, that your conduct was necessary, that it doesn't justify the killing. But for some level, it mitigates it. It is. It's not. It's a little hard to see. So let's suppose someone is angry at you, but they're clearly unarmed and they're clearly not going to escalate. And they're going to slap you, and you say, well, I'm not going to let them slap me. I'm not going to let them punch me. But they're not going to beat or rape or kill you. And let's just suppose we know that, right? And nonetheless, you take your gun and you shoot them, right? That's going to be imperfect self-defense because you've escalated beyond a certain level. It's easier to see before we have stand your own ground because we've got that retreat. So involuntary manslaughter, and we'll look at North Carolina's in just a second. You have no intent to kill, but death occurs because of an unlawful act. This is usually caused where you have wanton or reckless conduct, but it doesn't rise to the level of your second-degree murder, usually where you've got malice. Extreme negligence and failure to act can constitute involuntary manslaughter. For example, you shoot a rifle at what you think is a deer, but you hit another hunter. Now, if you're just careless in the way you're shooting, it's not like this hunter was chasing the deer and he was right behind it and you shot at the deer and your shot went wide. This is, you shot at a movement in the woods, turned out to be a hunter, not a deer. That's an involuntary manslaughter charge. We also have in some states vehicular homicide, where you used your car in some ways negligently. You were speeding. Sometimes in some states you're driving under the influence. Let's look at North Carolina's to make this a little bit clearer. So North Carolina has both voluntary and involuntary manslaughter. Voluntary manslaughter requires an intentional act that is a felony that is likely to cause death. Involuntary manslaughter, still we've got an intentional act, but it's not naturally dangerous. I misspelled naturally there. but it's still negligent. Now, North Carolina has a vehicular homicide. We kind of split it. We have felony and we have misdemeanor. So felony death by motor vehicle, misdemeanor death by motor vehicle. Those can be categorized as vehicular manslaughter or vehicular homicide. I said there's 6 charges in North Carolina. First-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter, felony death by motor vehicle, which usually means in North Carolina you killed somebody while driving drunk. Or misdemeanor death by motor vehicle, you killed somebody by a reckless act, which didn't include drunk driving. So you were speeding, you ran a stop sign, you didn't pay attention, you changed lanes, you ran someone off the road. That'd be misdemeanor death by motor vehicle. And remember, a felony is typically charged with, in North Carolina, 99 times out of 100, 2 years or more in a prison. A misdemeanor is usually a number of months in jail. So a big difference between the two. All right, a couple more points here to look at. We've got suicide, assisting suicide, and euthanasia. So under the law, and again, this is kind of a holdover from religion. Under classic Christianity religion, suicide is a mortal sin. You are not allowed to take your life. Your life in classical Christian theology belongs to God. To take your own life is to steal from God. It is a sin and it's unlawful. Matter of fact, it's a mortal sin. Most states have abolished this. It's not a crime. We're not going to put someone in prison for trying to kill themselves. Now, doesn't mean we can't commit them. If you have someone who is suicidal and is depressed or has a mental issue, we still have the ability to bring them into custody and do something like that, but it's not a crime. All right, now we've got assisting suicide. What happens if you help someone kill themselves? Well, states have an option. Some states will make this a crime of a homicide. Other states will carve out a specific charge, and that is assisting a suicide. Now, more than that, what happens if you're not assisting, but you're actually doing the act, mercy killing, where you're killing a terminally ill person or an individual with only a very short period of time? Well, there was a big fight about this. Went up to the Supreme Court of the United States, and different states have passed laws. Usually they're called death with dignity laws. And in this case, what happens is, I think Oregon has it, if I'm not mistaken, Oregon or Washington State. So you are interviewed by a medical practitioner, doctor, who judges you having a very short time to live, very often in a painful situation. He then, and sometimes there is a requirement, you have multiple doctors, and different states and different countries do this in different ways. You are required then, after the second interview, there has to be a waiting period, and then you can get a prescription for an excessive amount of drugs, enough drugs to kill you. Very often this is a morphine, which will suppress respiration and involuntary. It'll basically kill you. And the argument is, if you go to a psychiatrist and you say, or a pharmacist, and you say, hey, I'm filling this prescription for Bob. Bob's going to kill himself, and the pharmacist knows, then Bob is assisting suicide. The pharmacist is, rather. So we do have in certain states limits on this. Okay, what about North Carolina? North Carolina has a statute called right to natural death. What we have in North Carolina, though, is not an inaction, but we excuse non-action. So what you have to have done is expressed a desire for a natural death. So very often this takes the form of a legal document drafted by a lawyer that says, in the event I'm in a situation where there is no hope of my recovery or I am brain dead, I wish that no extraordinary means, including the providing of water and food, are used to extend my life. That can be done, and it is technically not a homicide. You are not allowed, however, to take a direct action. You can't say, okay, well, he wanted a natural death. He's suffering. I'm going to put a pillow over his face. That becomes a homicide. As far as suicide is concerned, North Carolina had suicide as a crime, but that was abolished in 1973. All right, well, we have one more hot button issue to address here, and this is, of course, unsettled law, and this is going to be abortion. So traditionally in North Carolina in 1973, about the same time we abolished suicide as a crime, we adopted the 20-week rule, which said 20 weeks after conception, up to 20 weeks after conception, you may have an abortion. You may terminate a pregnancy. And I'm not going to use the term baby or fetus here and make it a loaded thing. So you can have your own moral opinions about that. There was also some cases where if it's a medical emergency, if the life of the mother was in danger, there was a septic pregnancy or something, you could have an abortion afterwards. In July of 2023, this last summer, we cut that back to a 12-week ban. Now, there was a fight to make it 8 weeks, but they kind of compromised at 12. There were some exceptions built in for the life of the mother, if there was a rape, if the child, baby, fetus, again, don't want to use a loaded term here, was the product of incest, or if there are life-limiting fetal abnormalities. One of the things interesting I think it does, and I have some questions about the constitutionality of this, is that it punishes any physician or party who administers drugs or gets drugs or uses any instrument for an abortion after this 12-week ban. But women are specifically not subject to punishment. So you don't punish the mother. This could be a hard constitutional argument, because the reason I have some questions is you're saying that if I help you to do X, I am guilty of a crime because X is wrong. Whatever X is, in this case, it's going to be procuring an abortion after 12 weeks. But you, having done that, the mother, you're not punishable. But me, having helped you, are. I'm not sure that's constitutional. So if we used an analogy, and analogies are always fraught with danger, but I think it will clarify you, and you can see a constitutional issue here. If I said it's wrong to rob banks, but if you go in and rob a bank, and you have gotten the gun to rob the bank from me, right, that I can be charged with providing a gun for robbing the bank, but you, the bank robber, can't be charged, I'm not sure that's constitutional. So I think that's one of the places it's going to play out. I think if you want to have a ban on abortion, you are probably going to have to criminalize in some way, you may be able to criminalize it at a lesser extent, the actions of the mother. Again, kind of outside the scope of the class, but obviously in the news and of importance. Okay, well, that pretty much concludes our homicides. Again, we looked at the 6 major ones in North Carolina: the murders, the first and second degree murders, the manslaughters, the involuntary and voluntary manslaughters, and the vehiculars, felony death by motor vehicle, misdemeanor death by motor vehicle. There are others. We're not going to look at them because they're very specific and rarely charged. Other than that, whenever you're ready, we're going to be moving on to some of our assaults and other crimes. I will talk to you then. Have a good morning, afternoon, or evening.